Good day, future lawyers. Welcome back. This is part 2 of the top provisions in Civil Law 1. You will also find some references from the books of Tolentino and Associate Justice Horato, as well as some relevant jurisprudence. Now let's get started. Article 25. Thoughtless extravagance in expenses for pleasure or display during a period of acute public want or emergency may be stopped by order of the courts at the instance of any government or private charitable institution. The rationale for this legal provision is succinctly pointed out by a respected civil law author. When the rich indulge in thoughtless extravagance or display during a period of acute public want or emergency, they may unwittingly kindle the flame of unrest in the hearts of the poor, who thereby become more keenly conscious of their privation and poverty, and who may rise against the obvious inequality. Article 26. Every person shall respect the dignity, personality, privacy, and peace of mind of his neighbors and other persons. The following and similar acts, though they may not constitute a criminal offense, shall produce a cause of action for damages, prevention, and other relief. Number 1. Prying into the privacy of another's residence. 2. Meddling with or disturbing the private life or family relations of another. 3. Intriguing to cause another to be alienated from his friends. And 4. Vexing or humiliating another on account of his religious beliefs, lowly station in life, place of birth, physical defect, or other personal condition. The constitutional injunction declaring the privacy of communication and correspondence to be inviolable is no less applicable simply because it is the wife who thinks herself aggrieved by her husband's infidelity who is the party against whom the constitutional provision is to be enforced. The only exception to the prohibition in the Constitution is if there is a lawful order from a court or when public safety or order requires otherwise as prescribed by law. Any violation of this provision renders the evidence obtained inadmissible for any purpose in any proceeding. Is alienation of affection actionable? Explain. Answer. Yes, the actionable character of this tort is now recognized in Article 26 of the new Civil Code. According to number 2 of this article, meddling with or disturbing the family relations of another shall produce a cause of action for damages, prevention, and other relief. Among the family relations protected is the relation between husband and wife. Consequently, any willful interference with such relation, resulting in the alienation of the affection of the husband or the wife, whether such interference constitutes a criminal offense or not, would be sufficient to produce a cause of action for damages. Article 27. Any person suffering material or moral loss because a public servant or employee refuses or neglects without just cause to perform his official duty may file an action for damages and other relief against the latter without prejudice to any disciplinary administrative action that may be taken. Is the refusal or neglect of a public employee to perform his official duty actionable? Explain. Answer. Yes, the refusal or neglect of a public employee to perform his official duty is actionable. This is clear from the provision of Article 27 of the new Civil Code. However, in order that a public employee may be held liable under this article, the following requisites must concur. Number 1. There must be a refusal or neglect of public servant or employee to perform his official duty. In other words, there must be nonfeasance, not malfeasance or misfeasance. Number 2. The refusal or neglect must be without just cause. Number 3. The duty must be ministerial, not discretionary. And number 4, the plaintiff must have suffered some material or moral loss as a result. Article 28. Unfair competition in agricultural, commercial, or industrial enterprises or in labor through the use of force, intimidation, deceit, machination, or any other unjust, oppressive, or high-handed method shall give rise to a right of action by the person who thereby suffers damage. From the foregoing, it is clear that what is being sought to be prevented is not competition per se, but the use of unjust, oppressive, or high-handed methods which may deprive others of a fair chance to engage in business or to earn a living. Plainly, what the law prohibits is unfair competition, and not competition where the means used are fair and legitimate. In order to qualify the competition as unfair, it must have two characteristics. Number 1, it must involve an injury to a competitor or trade rival, and 2, it must involve acts which are characterized as contrary to good conscience or shocking to judicial sensibilities or otherwise unlawful. In the language of our law, these include force, intimidation, deceit, machination, or any other unjust, oppressive, or high-handed method. The public injury or interest is a minor factor. The essence of the matter appears to be a private wrong perpetrated by unconscionable means. Article 29. When the accused in a criminal prosecution is acquitted on the ground that his guilt has not been proved beyond reasonable doubt, a civil action for damages for the same act or omission may be instituted. Such action requires only a preponderance of evidence. Upon motion of the defendant, the court may require the plaintiff to file a bond to answer for damages in case the complaint should be found to be malicious. If in a criminal case the judgment of acquittal is based upon reasonable doubt, the court shall so declare. In the absence of any declaration to that effect, it may be inferred from the text of the decision whether or not the acquittal is due to that ground. Article 30. When a separate civil action is brought to demand civil liability arising from a criminal offense, and no criminal proceedings are instituted during the pendency of the criminal case, a preponderance of evidence shall likewise be sufficient to prove the act complained of. Civil liabilities are compensated in the form of damages. Our jurisdiction recognizes that a crime has a private civil component. Thus, while an act considered criminal is a breach of law against the state, our legal system allows for the recovery of civil damages where there is a private person injured by a criminal act. It is in recognition of this dual nature of a criminal act that our revised penal code provides that every person criminally liable is also civilly liable. This is the concept of civil liability ex delicto. This is echoed by the new Civil Code when it recognizes acts or omissions punished by law as a separate source of obligation. This is reinforced by Article 30 of the same code, which refers to the filing of a separate civil action to demand civil liability arising from a criminal offense. This distinction also agrees with the essential principle in our legal system that while a criminal liability carries with it a corresponding civil liability, they are nevertheless separate and distinct. In other words, these two liabilities may coexist, but their existence is not dependent on each other. The Civil Code states that when an accused in a criminal prosecution is acquitted on the ground that his guilt has not been proven beyond reasonable doubt, a civil action for damages for the same act or omission may be filed. In the latter case, only preponderance of evidence is required. This is supported by the rules of court, which provides that the extinction of the criminal action does not result in the extinction of the corresponding civil action. Article 31. When the civil action is based on an obligation not arising from the act or omission complained of as a felony, such civil action may proceed independently of the criminal proceedings and regardless of the result of the latter. In relation to Article 2177, responsibility for fault or negligence under the preceding article is entirely separate and distinct from the civil liability arising from negligence under the Penal Code. But the plaintiff cannot recover damages twice for the same act or omission of the defendant. Question. What is meant by a civil action based on an obligation not arising from a criminal offense under Article 31 of the new Civil Code? Answer. We all know that obligations may arise from law, contracts, quasi-contracts, criminal offenses, or quasi-delicts. Therefore, when Article 31 of the new Civil Code speaks of a civil action based on an obligation not arising from a criminal offense, it simply means a civil action based on an obligation arising from the law, a contract, a quasi-contract, or a quasi-delict. Article 33. In cases of defamation, fraud, and physical injuries, a civil action for damages, entirely separate and distinct from the criminal action, may be brought by the injured party. Such civil action shall proceed independently of the criminal prosecution and shall require only a preponderance of evidence. Question. What is meant by independent civil actions under Articles 32, 33, and 34 of the new Civil Code? Answer. The so-called independent civil actions under Articles 32, 33, and 34 of the new Civil Code refers to the civil actions based on certain criminal offenses such as a. Interferences by public officers or employees or by private individuals with civil rights or liberties. B. Defamation. C. Fraud. D. physical injuries, or E. Refusal or neglect of a city or municipal police officer to render aid or protection in case of danger to life or property. According to the Code, such civil action shall proceed independently of the criminal prosecution and shall require only a preponderance of evidence. Under Article 33 of the Civil Code, a civil action entirely separate and distinct from the criminal action may be brought by the injured party in cases of fraud, and such civil action shall proceed independently of the criminal prosecution. Article 35. When a person claiming to be injured by a criminal offense charges another with the same, for which no independent civil action is granted in this code or any special law, but the justice of peace finds no reasonable grounds to believe that a crime has been committed, or the prosecuting attorney refuses or fails to institute criminal proceedings, the complainant may bring a civil action for damages against the alleged offender. Such civil action may be supported by a preponderance of evidence. Upon the defendant's motion, the court may require the plaintiff to file a bond to indemnify the defendant in case the complaint should be found to be malicious. If during the pendency of the civil action an information should be presented by the prosecuting attorney, the civil action shall be suspended until the termination of the criminal proceedings. If the acquittal of the accused is on the ground that his guilt has not been proved beyond reasonable doubt, a civil action to recover damages based on the same act or omission may still be instituted. On the other hand, if the acquittal is on the ground that he did not commit the offense charged, or what amounts to the same thing, if the acquittal proceeds from the declaration in the final judgment that the fact from which the civil liability might arise did not exist, the subsequent institution of a civil action to recover damages is, as a general rule, no longer possible. There are, however, two exceptions to this rule. They are, first, where the civil action is based on an obligation not arising from the act or omission complained of as a felony, and second, where the law grants to the injured party the right to institute a civil action which is entirely separate and distinct from the criminal action. Article 36. Prejudicial questions which must be decided before any criminal prosecution may be instituted or may proceed shall be governed by rules of court which the Supreme Court shall promulgate and which shall not be in conflict with the provisions of this code. A prejudicial question is one which arises in a case the resolution of which is a logical antecedent of the issue involved therein. It is a question based on a fact distinct and separate from the crime, but so intimately connected with it that it determines the guilt or innocence of the accused. It must appear not only that the civil case involves facts upon which the criminal action is based, but also that the resolution of the issues raised in the civil action would necessarily be determinative of the criminal case. The two essential elements of a prejudicial question are A. The civil action involves an issue similar or intimately related to the issue raised in the criminal action, and B. The resolution of such issue determines whether or not the criminal action may proceed. That is it for this video, and thank you so much for watching. Please subscribe and also like Pinay Jurist on Facebook and follow Pinay Jurist on Twitter. Bye!